Welcome to the 33rd lecture of this lecture series on international arbitration practice. This lecture is a part of chapter 2 on invoking arbitration in international commercial arbitrations and in international investment arbitrations. In the past 9 lectures, we have been dealing with how to draft a notice of arbitration in an ICSID arbitration. We have also been using a detailed checklist to aid us in drafting the notice of arbitration. In this lecture, we complete the checklist and we also provide the link to the checklist in the description to this video. Feel free to download the checklist and use it for drafting notices. The 11th part of the checklist relates to reliefs sought. Reliefs are the most important parts of a notice or request for arbitration. The purpose of the notice of arbitration, the portion relating to reliefs in a notice of arbitration under the ICSID is twofold: to request ICSID to constitute the tribunal and to provide an indication of the reliefs to be sought in the tribunal. This is captured as items 61 and 62 of the checklist. Let's see how the reliefs figure out in the notice of arbitration in Discovery LLC versus Slovakia. 10. Request for relief. Para 109. For the foregoing reasons, the claimant respectfully requests that a tribunal be constituted in accordance with the convention and the rules as proposed above to resolve the claims set forth in this request for arbitration as may be amended in due course, and that the tribunal render an award in favor of the claimants containing the following relief, and then it goes on. Para 109 of the notice requests constitution of an arbitral tribunal as per the ICSID convention and the relevant rules in order to resolve the claims in the request. An important point is to be noted is in the brackets containing the phrase as may be amended in due course, meaning that the claims made in the notice of arbitration could be amended as is usual in complex arbitration. Note that Rule 2.2a of the ICSID institution rules in its relevant portion lays down the following as required in a request for arbitration. A description of the investment and of its ownership and control, a summary of the relevant facts and claims, the request for relief, including an estimate of the amount of any damages sought. So, this is the minimum requirement for reliefs in an ICSID arbitration. That is, the request for arbitration should be accompanied with the request for relief and including an estimate of any damages that has been sought. Right? Okay. Next, the notice lists out the reliefs sought vis-a-vis the claims. The notice is the Discovery versus Slovakia. The first relief sought is a declaration regarding the jurisdiction and competence of ICSID. 109.1. A declaration that the dispute is within the jurisdiction and competence of the center and the tribunal. Note that the seeking a relief of this sort is not common in all notices. For instance, the notice in SIA North Star versus Norway does not contain such a relief. Now, the subsequent reliefs in Discovery versus Slovakia relate to the substantive aspects. And it says, a declaration that the respondent has breached the BIT by expropriating the claimant's investments without complying with the requirements of the BIT, including payment of prompt, adequate and effective compensation, by failing to accord fair and equitable treatment and or full protection and security to the claimant's investments, by taking unreasonable and or discriminatory measures that impair the management, operation, maintenance, use, enjoyment, acquisition, expansion or disposal of the claimant's investments, by discriminating against the claimant as a foreign investor, and by failing to observe obligations entered into with respect to the claimant's investment. 1093. A declaration that the respondent has breached customary international law by violating the minimum standard of treatment of foreign investments and by expropriating the claimant's investments without observance of due process and payment of prompt, adequate and effective compensation. 109.4. An order directing respondent to pay to the claimant full reparation in accordance with the BAT and customary international law including compensation for damages sustained as a result of the aforesaid expropriation in an amount to be established in the proceedings, but which is presently estimated to be in the region of 2.11 billion, and which amount may be further developed and quantified in the course of these proceedings, plus compound interest thereon in accordance with the applicable law and grossed up for any taxes that may be imposed by the respondent on or affecting such compensation. As one would notice, both declaratory and compensatory or reparatory reliefs have been sought. The remaining reliefs are routine reliefs for costs, interest, and an open-ended request for relief. 109.5. An order directing the respondent to pay all costs and expenses reasonably incurred by the claimant in the course of this arbitration proceeding, including but not limited to the fees and expenses of the centre and the arbitral tribunal, and the costs and expenses of legal representation, plus interest thereon in accordance with applicable law. 109.6. An order granting pre-award compound interest on all compensatory damages from the date of each breach to the date of issuance of the award, and post-award compound interest on all amounts awarded from the date of the award to the date of payment. And 109.7. Such other and additional relief as may be appropriate under the applicable law or may otherwise be just and proper. The reliefs sought in SIA North Star versus Norway notice are more simplified. A. Finding that Norway has breached its obligation under the BIT. B. Directing Norway to pay damages in an amount to be proved at the hearing, but which the claimants at present estimate to be in excess of so and so over the life of their operation. C. Directing Norway to pay the claimants pre and post award interest on all sums awarded. D. Directing Norway to pay the claimants costs associated with these proceedings, including professional fees and disbursements. E. Ordering such other and further relief as the tribunal deems available and appropriate in the circumstances. Now we go to the last part of the checklist, which deals with miscellaneous items. In the notice in Discovery vs. Slovakia, a footnote number 46 is appended to para 109 and states, the claimant hereby reserves their right to amend or supplement this request for arbitration. Usually this forms a part of the operative portion of a notice of arbitration. It is item number 65 of the checklist that we are currently using. The SIA North Star notice does not contain this reservation of right to amend or supplement the notice of arbitration, but it is recommended to have it. Item 66 of the checklist relates to litigation funding. Note that Rule 14.1 of the ICSID arbitration rules provides 1. A party shall file a written notice disclosing the name and address of any non-party from which the party, directly or indirectly, has received funds for the pursuit or defense of the proceeding through a donation or grant, or in return for remuneration dependent on the outcome of the proceeding, third party funding. If the non-party providing funding is a juridical person, the notice shall include the names of the persons and entities that own and control that juridical person. Now, Rule 14.2 prescribes when to comply with this obligation of disclosing third party funding. It says, 2. A party shall file the notice referred to in paragraph 1 with the Secretary General upon registration of the request for arbitration or immediately upon concluding a third party funding arrangement after registration. The party shall immediately notify the Secretary General of any changes to the information in the notice. The obligation to disclose third party funding therefore kicks off only after registration of the request for arbitration. Nevertheless, if some arrangement is already in place, there is nothing that prevents a party from disclosing the same. Now, items 67 and 68 of the checklist provides for signature of the party or representative and mentioning the date of the request for arbitration. This is drawn from Rule 2.1d of the ICSID institution rules, which states 1. The request shall D. be signed by each requesting party or its representative and be dated. So, along with the date, the place from where the notice of arbitration is issued is also mentioned. Now, item 69 is the endorsement that the notice which is issued by a law firm is issued on behalf of the claimant. Item 70 calls for exhibits and legal authorities to be listed down serially. Claimant's documents or exhibits are usually labeled with the prefix C, indicating that it is a claimant's exhibits, followed by the serial number of the exhibit. For example, C1. Legal authorities are prefixed with CLA and followed by the serial number. Example CLA1, that is the claimant's legal authorities. Item 71 is a lodging fee published in the ICSID schedule of fees. Rule 1.1 of the ICSID institution rules provides any contracting state or a national of a contracting state wishing to institute proceedings under the Convention on the Settlement of Investment Dispute between states and nationals of other states convention shall file a request for arbitration or conciliation together with the required supporting documents request with the Secretary of General and pay the lodging fee published in the schedule of fees. The schedule of fees effective from 1 July 2022 can be accessed from the link provided in the description to this video. The last item in the checklist, item 72, pertains to the use of expedited procedure in chapter 12 of the ICSID arbitration rules. Expedited arbitration is arbitration in a time-bound manner where there are temporal and spatial constraints placed on the arbitral proceedings. For instance, Rule 81.1 provides that the memorial and counter-memorial are to be filed within 60 days of the first session. It further provides that the memorial and counter-memorial should not exceed 200 pages. So, if parties wish to opt for expedited arbitration, the notice may call upon the other party to consent for such arbitration. But, as per Rule 75.1, joint consent of both parties is required. At any time, the parties to an arbitration conducted under the convention may consent to expedite the arbitration in accordance with this chapter, expedited arbitration, by jointly notifying the Secretary General in writing of their consent. So that's all in this lecture. Bye bye and stay safe.